Hello, everyone. I'm very honored to have a presentation today. I'm thankful for the René Cassin Foundation and the Japan Foundation, last but not least, that Japanese Consulate Office in Strasbourg, in particular Ms. Saito, who has supported this event. The topic which is given to me is encounter between Japan and Europe and its consequences in the context of human rights. Therefore, I chose a specific topic, same-sex marriage. Using this topic, I try to show an encounter between Japan and Europe. I share my PowerPoint. You can see.
Dear Professor, everything is fine. We can see your PowerPoint
presentation. Okay, thank you. Same-sex marriage not have been legally acknowledged in Japan. That does not mean that there is no homosexuality in Japan. In fact, since a long time ago, homosexuality has existed. For example, in the Sengoku period of wearing states in Japan from 1467 to 1615, it is said that Kosho, who was a position in a samurai family similar to a page, served as homosexual partners of pederast lords. In Japanese performing art, it is not unusual for a man to dress like a woman and for a man to dress like a man. For example, kabuki, you can see the figure on the PowerPoint. A Japanese traditional drama is performed only by male actors who play men and women. Similarly, a contemporary drama, the Takarazuka Review, is performed only by female actors, and the audience is mainly women. The male characters played by female actors are particularly popular. Boys' love, homosexual love story, is an established category in Japanese manga. Gay people also play an important role in entertainment. Every day, you can see openly gay presenters and commentators on TV. You can also find gay clubs in Kabukicho, Shinjuku Ward in Tokyo. On the surface, homosexuality seems to have been accepted in Japanese culture. Religions and thought in Japan have not denied or condemned homosexuality. In fact, in Buddhism, Kannon-sama, you can see the figure, a deity of mercy, does not have a specific gender and can be seen as a man or a woman. Homosexual sex between men was banned in early Meiji period, influenced by European culture. Soon later, the ban was abolished. Since then, homosexuality has not been banned. In Europe, homosexuality had been considered as taboo because of religion, in particular Christianity, and therefore liberation movements were necessary so that members of the lesbian, gay, bisexual, and transgender LGBT community could be accepted in society. Not all, but many European countries have succeeded in legalizing same-sex marriage as an institution based on the non-discrimination principle. We can see huge progress in acknowledging LGBT rights in Europe, thanks to LGBT movements. On the other hand, on the whole, Japanese culture and thought have been tolerant of homosexuality, and as a result, liberation movements of homosexual people had not happened to the same degree as in Europe until recently. Until now, Japan has still not been able to adopt a law to establish same-sex marriage. In addition, Japan is still a conservative society. Recently, the Japanese Supreme Court held that the Japanese family legislation law, which does not accept separate surnames for married couples, is compatible with the Japanese constitution. I myself, my name is Yumiko NAKANISHI, but that is not legal name. That is my legal name is others. But the official, that is a separate surname is not accepted. Therefore, I cannot use my name Nakanishi, so officially in legal term. Currently, there were some movements and discussion regarding same-sex marriage in Japan as well as in Europe. Even in such conservative Japan, we can see a big change regarding same-sex marriage. In this presentation, firstly, I would like to present briefly the situation in Europe regarding same-sex marriage. Then, I would like to show you the recent development regarding same-sex marriage in Japan. I am a researcher of European Union law. The EU does not have competence in determining the status of family law, determining the status of family members, including regarding marriage. Competence in this field belongs to the EU member states. They can determine the law regarding marriage and the status of married individuals. Therefore, each state can decide whether to allow same-sex marriage or not. In some European countries, such as the Netherlands, Belgium, Germany, France, Austria, Denmark, Finland, Ireland, Luxembourg, where I live now, Malta, Portugal, Spain, and Sweden, same-sex marriage has been legalized, while other European countries, such as Romania and Bulgaria, have not acknowledged the right to same-sex marriage. In the common case, in 2018, the issues of same-sex marriage in Romania was dealt with. Mr. Coleman is a Romanian and married Mr. Hamilton, an American, in Brussels, where same-sex marriage has been legalized. they wanted their marriage to be recognized in Romania so that Hamilton could live there. However, the Romanian authority did not acknowledge it. Therefore, they took action before a Romanian regional court and argued that the decision of the authority was discriminatory on the ground of sexual orientation. Finally, the Romanian Constitutional Court decided to seek a preliminary ruling before the Court of Justice of the European Union. The Court of Justice held that even if a matter belonged to a member state's competence, the member states have to comply with European Union law, in particular, the provisions of freedom to move and reside in the territory of the member states. Furthermore, the court held that the refusal of the authority of a member state to recognize the status of same-sex marriage violates the right to free movement of EU citizens. That means that the free movement of the same-sex spouses of EU citizens must be guaranteed even in member states which have not legalized same-sex marriage, although EU law does not lay down family status law, and the member states can further decide whether same-sex marriage is allowed or not. This judgment enlarged the scope of legalized same-sex marriage geographically, even in states where same-sex marriage has not yet been legalized. In so judging, the court relied on the freedom of movement of persons, one of the fundamental freedoms which is laid down in Article 21, paragraph 1 of the TFEU. The principle of non-discrimination, including based on sexual orientation, is laid down in Article 19 TFEU and Article 21 of the EU Charter of Fundamental Rights. Also, the European Union does not have competence to rule on the rights of the LGBT community, for example, same-sex marriage as an institution. The European Union obliges the member states to comply with European Union law, in particular, the EU values and principles, as well as the EU measures which reflect them. However, it is of note that even in Europe, the rights of members of the LGBT community has not been thoroughly, completely acknowledged. In the VMA case, a pending case before the Court of Justice, the Bulgarian state refused to recognize the same-sex parentage of a child. Advocate General Kokot showed that it could be possible to justify such a refusal based on national identity according to Article 4, Paragraph 2, TEU. She indicated that the Court of Justice had held that the member states are not required to provide for the institution of marriage between persons of the same sex in their national law, and that the European Court of Human Rights had held that a state is not required to authorize a simple adoption of a child by homosexual partner of the child's biological mother. In addition, recently in Hungary, the parliament passed a law banning LGBT content in educational materials under 18s. According to the law, companies and large organizations will be banned from running advertisement featuring gay people insofar as their advertisement target minors. In addition, the law laid down that TV shows and films containing gay characters will be allowed only after the watershed. Facing this new law, the European Commission President Ursula von der Leyen called the law a shame. Furthermore, 17 EU leaders signed a joint letter expressing deep concern and in order to fight together against discrimination towards the LGBT community. The member states have competence to make national law in order to protect young people. However, they have to respect the EU's values and principles, including the principle of non-discrimination. The rights of members of the LGBT community, including the right to same-sex marriage, have not been acknowledged in all of the EU member states. However, the principle of non-discrimination related to sexual orientation is one of the EU principles, and as a result, they are obliged to comply with that principle. The reactions of the Commission and EU leaders to the Hungarian law show that the principle of non-discrimination is firmly embedded in the European culture. Now, I will move on to discuss legal status of same-sex marriage in Japan. Same-sex marriage in Japan is still not legal. Article 24 of the Japanese Constitution lays down that marriage should be based only on the mutual consent of two parties of the opposite sex. That means that marriage between two parties of the opposite sex as an institution is established. For reference, the lawful age of marriage for men is 18 and for women 16. It is needless to say that there are LGBT people in Japan too. More and more, we can see movement for the rights of the LGBT community. The rainbow flag as a symbol for such movement can be also seen in Japan. As a result of those movements, some municipalities have officially recognized partnership of LGBT couples. Increasingly, people have taken action before the courts so that their marriage could be recognized officially. Following this, for the first time, on 17th of March 2021, the Sapporo Regional Court, which is located in Hokkaido Prefecture, the northernmost prefecture in Japan, held that non-acceptance of same-sex marriage is incompatible with the Japanese Constitution in particular Article 14, which provides for equality and non-discrimination. In this case, 3 same-sex couples sued the state, saying that their inability to marry violated Article 14 of the Constitution. Article 14, paragraph 1 of the Constitution lays down all of the people are equal under the law, and there shall be no discrimination in political, economic, or social relations because of race, creed, sex, social status, or family origin. Firstly, the court confirmed that Meiji civil law, which was regulated in 1896 after the Edo period, was drafted by referring to foreign civil law of 8 countries, including France, Italy, and Belgium. And at that time, same-sex marriage was not established as an institution in those countries. Secondly, the court mentioned status of same-sex marriage in different countries. For example, the court explained that in 1989, Denmark introduced same-sex civil partnership, and Germany and Finland followed in 2001. Luxembourg and Ireland in 2004. Same-sex marriage as an institution began to be introduced in the Netherlands in 2000, in Belgium in 2003, and so on. In addition, the court stated that in 2017, in ASEAN, Taiwanese Constitutional Court held that the National Civil Code was incompatible with the Constitution. Next, the court confirmed that the American Chamber of Commerce in Japan pointed out that Japan was the only G7 country that had not acknowledged same-sex marriage partnership or marriage and partnership as an institution. The chamber pointed out further the same-sex spouses of foreign nationals in Japan who had married in another country could not obtain a spouse visa, and as a result, same-sex couples were not coming to work in Japan. In addition, the court showed that in 2015, the Shibuya ward and Setagaya ward in Tokyo introduced same-sex partnership as an institution, and now around 60 local governments have introduced it. The court recognized that same-sex marriage had not been allowed under the Meiji civil law, as well as under the amended civil law of the year Showa 22, that is to say 1947, because it was thought that homosexuality was caused by mental illness in Japan as well as in foreign countries. Now, homosexuality is no longer thought to be caused by mental illness in Japan either. Furthermore, the court pointed out that public awareness of discrimination based on sexual orientation is growing and will continue to grow. Also, the court admitted that the legislature has discretion to take public awareness into account in determining amendments of family law. It held that in considering whether it is still rational for courts not to provide a legal instruments for homosexual people so that they could enjoy the rights or legal effects derived from legal marriage. It should also take public awareness into consideration in giving a judgment. The court acknowledged current differences in legal effects based on personal status, for example, inheritance, between marriage of homosexual people and that of heterosexual people. The court held that such differences are no longer rational. Finally, the court decided that the relevant family law is not compatible with Article 14, Paragraph 1 of the Japanese Constitution. Following this judgment, the Special Committee on Sexual Orientation and Gender Identity of Liberal Democratic Party, LDP, considered submitting a bill of LGBT rights with Komeito, the LDP's coalition party. The Olympic Games will be held soon in Japan in July and August. This was considered an opportunity to pass a bill because the Olympic Games are considered a festival not only of sports, but also a festival celebrating peace and diversity. Additionally, Japanese parliamentarians are aware of this public conception of the Games across the world. Regrettably, because of COVID-19, discussion of the Olympic Games in Japan revolved around the game, whether the game should be done or not, rather than promoting diversity. Furthermore, some conservative politicians among the LDP strongly opposed the bill, and the bill could not be approved in this term of session of the parliament. The issue of same-sex marriage as an institution is not an old issue. Denmark was the first country which acknowledged same-sex partnership as an institution. That was in 1989, about 30 years ago. Since then, the recognition of the LGBT rights has progressed rapidly. However, LGBT rights have not yet been completely established, even in Europe. In addition, the right of same-sex married couple to adopt children has been discussed. In Japan, same-sex marriage as institution is still not legally established. But we can see some changes, including the landmark judgment regarding same-sex marriage. I hope that in the near future, Japanese family law might be amended. Now, I would like to comment on the landmark judgment by the Sapporo Regional Court from the perspective of encounter between Japan and Europe and its consequence in the context of human rights. Usually, as an EU researcher, I read the decision of the Court of Justice of the European Union. This time, I read the judgment by the Sapporo Regional Court regarding same-sex marriage. The judgment stated that Meiji civil law was drafted by referring to European civil law, and at that time, same-sex marriage was not emphasized at all in European countries. Then, it is of note that the judgment mentioned in a knowledgeable manner the legal development and current state of same-sex partnership and marriage as an institution and related case law in the world, including Europe and Asia. The judgment was influenced by global developments in this area, in particular in Europe. The day before yesterday, I participated in a regular joint seminar between Japanese judges and researchers of German constitutional law. Japanese judges are eager to study foreign law and foreign case law, and Japanese researchers research foreign law with keen interest. I think that such studies led to the landmark judgment by Sapporo Regional Court. Japanese law was created by referring to European law, and Japanese law has been developing with the development of European law. I am not expert of socio-legal study. However, I would like to add my prognosis. Sometimes it is said that democracy has never quite taken root on Japanese soil. On the surface, there are not strong demonstrations or NGOs activities in Japan, and that citizens are indifferent towards politics. Even if that is true, it is important to make laws in Japan. If a law regarding same-sex marriage as an institution will be adopted, citizens' consciousness for recognition of diversity will be strengthened. In addition, Japanese people are relatively tolerant towards religions, and homosexuality has not been taboo. Therefore, once a law has been passed, the rights of members of the LGBT community might be easily accepted. A strong point of Japanese government and Japanese people is having a spirit of legal compliance. For example, the Japanese government assesses whether Japan could abide by international agreements before concluding them. For example, Japan concluded the Paris Agreement. That means that Japan is ready to comply with it. The EU and Japan concluded the Economic Partnership Agreement and the Strategic Partnerships Agreement, which contain certain values such as democracy, respect for human rights, and the rule of law. That means that those values will be guaranteed in Japan. Thank you for your attention.
Thank you, dear professor, for this interesting presentation. I don't see questions in the chat. Do you want probably to ask them now orally in order to read them down?
Yes, if you have some comments or questions from the floor, I would like to answer them.
I hope that everyone can hear us now. Okay, I don't see. I see a question in the chat. How could Sapporo District Court of the mentioned case could scrutinize deeper about the theme than other panel or judges? What was the difference? This question is coming from Shihiro.
Maybe Chihiro-san is a Japanese judge, and so she knows better than me, I think. So I just read the judgment of Sapporo Regional Court, and I don't know. So I don't know details. So maybe the Chihiro-san could can make comment. Could make comments. I'm not sure.
I was a bit wondering how could they observe the cases so deeply as you explained, like mentioning about the cases in the foreign country. So I was imagining that the attorney was making a very good point about introducing the international cases, but I was just curious about it. So thank you very much for your lecture.
Yes. So maybe I can add some comment about it. So as I told, or as I said, day before yesterday, I participated in the regular meeting between Japanese judge, including the judge of Supreme Court, and researchers of German Constitutional Court. And next seminar, former president of the German Constitutional Court will make a presentation from Japanese judge, and I have an impression. So Japanese judges are very so eager to study foreign laws and foreign case law development. So, so I think they are very busy every day, and they so Chihiro-san, I think so, and but they may be using their free time. They read some development about foreign case. No, maybe that is a meeting between a researcher of German constitutional law, but maybe I think there are also meeting between Japanese judge and French law or Italian law. I'm not sure, but yes, they are interested and they want to make use of those studies in their judgment, I think. So and next meeting the topic will be a partnership. So partnership. So that some judges were very interested in this topic, and yes, I am. So I am just a researcher, and and every day I concentrate on research, but I'm very so after the meeting I thought I should more concentrated on my study, so to give to give us some useful information for the judges in Japan, I thought. Yes.
Thank you very much. We
Yes.
would like to learn more. And I think you have another question on your chat box.
Uh-huh.
Yes, we have a comment. Thank you so much. It's interesting. And afterwards, another question from David Alexander Bosset, who is asking that, would you say there is a Japanese researcher who said in the early 1960s that Japanese people do not like law. Would you say that this has changed over the decades as Japan has been gradually westernized itself in certain ways and has been looking at foreign countries' legal framework? Perhaps Japanese people's relation with law has changed.
Yes, it is interesting comment. Yes, early 1960s, Japanese people do not like law. So I am not sure, but it is said. So that's only for my general knowledge. I can answer only from my general knowledge. And Japanese law, Japanese people don't like law. Rather, Japanese people don't like litigation. So they hesitate to take action before national court. It is very true. It was very true. And now, so Japanese people are changing maybe. So they are ready to claim or take action before national court to some extent. Yes. But so you there are I am also a public lawyer, so therefore the human rights or so the constitution, so I am interested in that, but the Japanese constitution has never been amended, so it is very it differs from European countries' constitution, German or the France or the other countries, but yes, foreign, Western, certain. So maybe I can add. I know only the universities in Japan. Also I studied in Germany. So there are always foreign law lectures. So, for example, I teach European Union law in Japan in several universities. And so many students participated in my lecture. So sometimes more than 100 people hear my lecture. So that means students are also interested in foreign law, including European Union law. And in Japan, there are not European Union law, but also common law lecture. So American or UK law, and French law and German law. So they can study foreign law at university, and in university there are professors who teach foreign law. I think, yes. Yes. Yeah. Yeah.
Thank you, dear professor, for this response.
Yes.
I don't know if we have any other questions from you participants. You still have 5 minutes in order to ask your questions. Well, I don't see any other questions in the chat. So if everyone agrees, we can finish this this meeting, I would like to thank again the Professor Nakanishi for this interesting lecture, for those also interesting answers to the questions.
Yes.
And also Shihiro Saito, who also participated actively in this lecture, and for the organization again of this training and his precious collaboration. I would like to thank the participants as well. And I invite you, if of course your time schedule allows you to join us. We are organizing a virtual drink between participants at 6:30. I can send to Shihiro the link if she wants, and also the professor to join us. It's not obligatory. It depends on you if you want to join us and discuss in different topics, not only law, but just have a meeting with us outside the context of this training session. I would like to thank you again, and see you later for those who are joining us.
Thank you very much.
Goodbye to everyone. Thank you again. Bye.